Objection, Your Honor.
Are you interrupting this court? No, you interrupted. I get to speak, then you can speak. We learned this in first grade. That's rude. She can't take every. Dontrell Jones. Here, Dontrell Jones, is that you, sir?
No.
That's you?
I'm Nick.
Welcome. And this is cause number 26 CR 768, the state of Texas versus Dontrell Tyrese Jones. And here is Mr. West, your attorney, and the prosecution is Mr. Laird. You were charged in this case, sir, with the second-degree felony of burglary of a habitation. And this indictment states this occurred on or about March 11th of 2026 in Jefferson County, Texas. And that's serious because that would carry with it up to 20 years in prison. But your criminal history has caught up with you. The indictment goes on to allege in paragraph 2 that you were convicted in the 252nd District Court of Jefferson County next door.
Objection, Your Honor.
Are you interrupting this court? No, you interrupted. I get to speak, then you can speak. We learned this in first grade. That's rude. She can't take everything down when people are speaking over each other. Please listen to me, and then you have a fair opportunity to be heard, okay? Let's do it that way, sir, like we learned in school. All right. Paragraph 2 goes on to allege that you were convicted of aggravated robbery. That's a first-degree felony. That was in 2018 in the 252nd District Court of Jefferson County, Texas, next door. After that was final, according to this, there was another, on that same day, there was another aggravated robbery conviction on that same date in the same court. So on September 17th, 2018, you were convicted twice of aggravated robberies. After those convictions became final, paragraph 4 of the indictment goes on to state that you thereafter committed the felony of a robbery, a second-degree felony, and you were convicted of that. I think I remember, because I remember faces. You were convicted of that in this court in September of 2025, last year. So if paragraph 1, if you were convicted of this new burglary of a habitation, and paragraphs 1 or 2, paragraphs 2 or 3, one or more of the aggravated robberies were proven true, and then this other robbery in this court on paragraph 4 was proven true, that would make you an habitual felon, which means the punishment range would be, so that you know, and you can make an intelligent decision on what you should do. You'd be looking at no less than 25 years in prison to life imprisonment. You're not eligible for probation, and the minimum is 25 years, and these are aggravated. This is a.
It's not an aggravated.
I'm sorry. The earlier convictions were aggravated robberies, but this one is a burglary of a habitation, which is not an aggravated offense. So it would affect your parole somewhat. But it would not be as severe on parole as though it were an aggravated case. So you're still looking at 25 to life, which is not good. All right, what are we doing?
If I get a little time, I'd like to have him evaluated. I have gone to the jail to talk to him. He's refused to come talk to me. This morning, I tried to talk to him again. He indicated that he's here for a theft and not for a burglary, and then walked away. Went back. I was trying not to sell it.
There's the indictment says burglary. The indictment says burglary. That's what the grand jury indicted you for right there. Burglary.
I've tried to go over the discovery.
That's the way that's the law. And it's up to the jury to decide if it's true or not.
Get a plea bargain?
Huh?
Get a plea bargain?
You got to talk to him with that. He's your lifeline. He's the man who helps you. Y'all have to do that privately. I can't get involved in that. But if it's fair, if something can be worked out, we'll do it. But 25 to life is not good. Y'all talk about it.
I would like if he'll talk to me.
Okay.
Yeah,
all right.
Yeah.
Well, work with him. He sounds like
I'm
he's an
trying.
intelligent guy. He's concerned about his life. Okay. James J. Nelson, please. Billy Ray Ross, I guess. Is that you, sir?
Yes.
All right. Let's just make sure, because of the seriousness of all of this, that there's no confusion on your part. There are three cases numerically in this order. 24 CR 1117 is an indictment, second degree felony of aggravated assault with a deadly weapon on or about April 20th, 2024. And that indictment not only alleges the second degree felony of aggravated assault with a deadly weapon, but one, two, three, four prior felony convictions. And this makes him a habitual felon. Correct, everybody?
Yes,
So
sir.
if convicted of that one, you're looking at, and if all of it was proven true, no less than 25 years up to life imprisonment. Do you understand? Yes. He's nodding.
Yes.
We have to, and she has to take down everything, and yeah, that's what we have to do. So speak out loud. And then the next case is 24 CR 1415. And in that one, it is alleged that on or about May 15th, 2024, you committed the third degree felony of unlawful possession of a firearm by a felon. And it states in that indictment that you were convicted out of the 337th District Court of Harris County, Texas, for a felony. And thus, anytime, as you know, it becomes not only a state crime, but a federal crime to commit unlawful possession of a firearm by a felon. And then there are three prior felony convictions, and that would bump this, if it was found true, to an habitual felon status in that case. And then finally, 25 CR 1738, that's a state jail felony of methamphetamine as alleged, but it goes on to allege the prior convictions. So in this one, I believe I'm right in stating that if you were found guilty and those prior felonies in the indictment as alleged were proven true, it's a state jail felony, but it would be punished as a second degree felony if you were convicted.
Yeah.
So you are looking at if all of this was proven true, you are looking at a minimum of 70 years in prison, a minimum to two life sentences and a 20-year sentence as the maximum. So that's a lot to think about. And Mr. Macon is a veteran attorney who helps his people. You know what? I've made some marks here on. You have two cases had Hebert Road, and another one had Twin City Highway, but
It didn't sound like it.
you must have told me it was 2244 Graves Avenue. Groves was your correct address. Was that right? Okay.
Yes.
All right.
Yeah.
I moved it there.
Oh, you moved. You got another one. Well, you're in jail right now. But
Yeah, I mean,
did you have another
3419.
homestead after Graves?
Yes, 3419 Hebert Road.
I'm sorry, Hebert.
Hebert.
Okay, then that's what's indicated on 25 CR 1738. I'm going to correct that then for everything else. All right.
No objection, Judge.
So 24 CR 1415 is changed from Twin City Highway to 3419 Hebert. I knew the Hebert family. Those names were named after him.
sure.
Yeah, it's going to be Beaumont, Texas. 05.
Yes.
Right. Yeah, I had three. I had Hebert Road and then I changed it to Graves because that's my writing, but so your final answer on this is 3419 Hebert is your road, is your, okay,
Correct that. So,
all right. Then it'll correct it there. Okay. So for the record, where we headed on this, because I'm looking at this plea bargain rejection, what was, can y'all read it in the record so
Yes, sir.
that
Yes, sir.
later on, that there's not a doubt, so that Mr. Ross is clear about what his options are.
Yes, Your Honor. In exchange for the defendant's plea of guilty in these cases, the state's offer was 25 years in the aggravated assault case appearing in 24 DCCR 1117 with a concurrent 25 years in the possession of a firearm by a felon case appearing in cause number 24D CCR 1415. That case allegedly having been captured on the police video. And lastly, a 20-year sentence to run concurrent in the possession of a controlled substance case appearing in cause number 25 DCCR 1738, Judge.
Okay, so one of them is an aggravated case, right?
Yes, sir.
And that's the 1117. The other ones are non-aggravated. So the parole loss would be different in those two versus the more serious parole situation in the aggravated assault. But these are all running together, right? I mean, not on top of each other.
Seeing as how the defendant has elected to reject the state's offer, we will file a motion to accumulate, Judge, or stack, in other words.
All right. So what would probably happen if is depending upon what you do, the way this would be tried, it probably would try one case,
That's right,
then the
Judge.
next one,
Yes,
then
sir.
the next one, and then they would end up running by law on top of each other.
That's
And
correct,
How
Judge.
much time do you have credited toward this now?
about 2 years, Joe.
2 years?
16 months.
But he's looking at having to serve 12 and a half, right, on your sentence?
Yes, sir.
Six head.
All right. So I have this plea bargain rejection, what you've done, and you've signed it, and so did Mr. Macon, because he does his stuff very thorough. So what you're doing is saying you're making a decision voluntarily, knowingly, intelligently, and based upon discussions with your attorney to refuse to accept this offer, go to trial, and we'll just try 1, 2, and 3. Okay. That's what we'll do.
Yes.
That's what we do.
Thank you, Judge.
620 times so far. We try cases.
I'll be able to see you.
That's what we'll continue to do. Reagan on Patrick Thomas.
So Judge, Mr. Laird and I have come to an agreement to amend his probation to add ISF to it.
Yeah.
The probation department has prepared that paperwork for that.
Okay.
So that would resolve his motion to revoke the probation.
Move forward, sir. Okay, we call 21-37471, the state of Texas versus Patrick Thomas. That's you, Mr. Thomas.
Yes, sir.
And you're here with Mr. Naldi, your attorney. The state's attorney is here. As you know, there was a motion to revoke unadjudicated probation filed in May of this year alleging a DWI, curfew violation.
Mr. The plan on this one,
Okay, you had intoxicating substance and then it being in arrears. So there were 4 violations here. And you're there, if the motion was granted and your probation was revoked, you would be looking at no less than 2, no more than, this was deferred. You would be looking at no less than 2, no more than 20 years confinement in prison if you were revoked. So, it's serious. Looks like everybody has agreed to modify the condition of your probation, and you would attend and complete the state intermediate sanction facility ISF substance abuse treatment program. It's a 90-day program. Is this what you want to do? Makes you a better person. Is this what you want?
Listen.
Okay. And you've talked this over with Ms. Manali, and that's your choice.
Yes, sir.
Okay. Everybody agree?
yes,
I'll sign this.
He's supposed to take care of the misdemeanor DWI, I believe, Wednesday, when his attorney there in that court is available. So that's when we can get the release for him to go.
Okay, you've signed this already, this motion, this order, correct?
I'm so sorry, yes, sir.
There it is. That's your name, looks like.
Yes, sir.
Okay, then what I'll do is, what do you want me to do with this motion? Just hold it in suspense to make sure that he satisfactorily completed it? Once he satisfactorily completed this, then we just drop the motion, right?
Yes, sir.
Okay, that's what we'll do.
Let's do
It's
that.
up to you.
Let's do that. Yes.
Do well, and then you can get out of this and. Thank you.
Thanks.
Thank you, Judge.
You're very welcome.